Hold on. When there's objection, you got to let us talk it out. Well, I'm glad I'm not the trier of fact because there's too many questions that I didn't get any information on. The 911 call says he punched me and snatched me up. Mr. Norowski didn't mention any punches. So if there were punches, when did they happen and where did they happen? But you certainly met the probable cause burden to send it downtown for whoever gets the trier of fact job to figure it out. So I'm going to bind over.
Get back together. They're now in the back of the house. But the testimony that this court has heard is they're there for a number of minutes. The argument has re-ensued. And then you hear the testimony that Devin leaves up the driveway with his father behind him. They walk, some period of distance of, 15 or 40 feet or somewhere in that proximity. And nothing is being said at that time period. It's like dead air, like what's going to happen? Is anything going to happen? And so there's that time of consideration at the end, and there's that significant time of consideration when they broke up their argument and went separate ways that I think should weigh in on this court's decision as to whether or not there's probable cause to support a position of first-degree murder. The defendant fired 3 times point blank at the chest of the victim. According to the testimony, he would stand over the victim with a smirk on his face, almost a point of pride or happiness in the shooting of his father. So when you take all of this into account, and I guess I would say this, one thing I think that's important about the 911 call is when you listen to the 911 call, when the sergeant on the other end asks Devin Hackney, what happened? What happened? He says, he hit me and put his hands on me, getting me out of the car, which is the exact same thing that Nick Norowski describes as the only physical interaction. So even the defendant in his 911 call doesn't bring up any physical activity, weapon drawn, threats made, anything like that. He says, my dad put his hands on me, got me out of the vehicle, but then 15 to 20 minutes go by where we're even separated. I'm in a house, he's at a park. We get back together, the argument pursues, but then there's a walk down the driveway with nothing further being said. And next thing you know, we have an eyewitness staring at Devin, drawing a gun, pointing at his father's chest and firing 3 shots point blank before standing over him with a grin. The jury instructions in the law on first-degree murder, as this court knows, specifically says that there is no time period required. You just take in all the factors in determining whether or not there's evidence to suggest premeditation and deliberation. I think for all the reasons I've stated and given the standard that this court is operating under, that we do believe that we've established first-degree murder as a bind over out of this district court and being sent to the circuit court.
Mr. Nasser.
Judge, please support. First and foremost, I have a lot of respect for this prosecutor. He's done a good job. But the facts are the facts, Judge. First-degree murder elements. The defendant intended to kill the victim. 2, the defendant thought out the killing beforehand. 3, the killing was not justified or excused. And 4, the killing was not the result of a sudden impulse. Let's go through this. And prosecutor did question, as did I, Mr. Norowski. In his own testimony, that this incident didn't happen necessarily in a vacuum, but he sees some physical contact between my client and his father. You see an individual that's being yanked out of a car. However, that ends that particular instant. That instance is done. Why? Because we know that Devin goes inside of his house, and we know that Alex Hackney goes for a walk. We know by the reading of the autopsy report that he is grossly intoxicated. The blood alcohol level and the intoxication level shows that. That's unquestionable what his blood alcohol was. To assume that someone was just having a casual conversation or was just reasonably talking with that type of indication is an impossibility. This court has seen too many cases to that effect. But let's talk about this. Nick says, hey, listen, I hear a bang, and I look outside, I see this, I see that Alex is yanking his son out of the car. There's a break, he goes inside the house, he continues doing whatever it is that he's doing. He then hears shouting again, and there's a specificity to the shouting. What was said out of his purview, but loud enough for Mr. Swarovski to hear from within his house. I have nothing in life. Fuck this. I took care of you. I gave you 3 cars. I've given you everything. Your mom has never done anything for you. Devin kept saying, no, dad, no, dad, no, dad. Nicholas then heard Alex saying repeatedly, if you're a big man, do it. If you're a big man, do it. That is not the conversation of a lucid individual having a regular conversation. The people's presumption is that, or their statement that can be inferred in any other way, is just not possible. It's clear what that meant. There is a clear argument, and he is big man to it, and he's approaching Devin. There's no question about it. Then, when you see a purview, when they do come into sight, what you see is Mr. Narosky, he sees my client backing up. Michigan, there's no right to, you don't have to necessarily retreat if you're being attacked. In this instance here, he's retreating. He's trying to extricate himself from this particular situation. What you do see is Alex walking towards him. Then, when they see this going down, reportedly he draws a gun, telling him to stop. But you don't hear that because there's about 5 to 10 seconds that this individual goes from his house and comes outside. There's nothing to be said about what was said. We do know for sure that this man had a pocket knife still on this person when he was at the hospital. Still. An individual that has an arm, and you have the testimony of Mr. Narosky. He's like, hey, listen, we don't carry pocket knives around here. We have it. An individual is shot. That happens. My client then goes inside of the home and calls 911 himself. That's the testimony of Mr. Narosky in and of itself. He calls 911. You hear this over the recording that the fine prosecutor indicated. You have an individual that's shot. You have an individual that has shot his father. But you have an individual that's hiding the kite. All respect to the family, both families. This is a lawsuit. This is not something good. You have an individual that has shown an aggressive tendency of grabbing somebody out of the car. You have an individual that is coming towards him saying, you're a big man, do it. That is not first degree murder by any degree. That is a sudden impulse. And that is an element that certainly the people cannot show. In Michigan, Judge, you have the ability to self-defend. And self-defense is noted, one moment. Self-defense is noted in, of course, under 780-929, use of deadly force by an individual. An individual who has not or is not engaged in the commission of a crime at the time he or she uses deadly force may use deadly force against another individual anywhere he or she has the legit right to be with no duty to retreat if either of the following applies. 1, the individual honestly and reasonably believes that the use of deadly force is necessary to prevent the imminent death or the imminent bodily harm of himself or herself or to another individual. That's logical. It's not a question of fact. A question of probable cause has been presented here. And if the evidence presented was a reckless discharge causing injury or a reckless discharge killing somebody, I would be in agreement with Mr. Lawrence. But that's not what's happened here. That's not what's happened. What you have is an individual that's approaching and imminent danger and an impulse response. That element the people cannot satisfy by the testimony that has been exhibited here today. Even the testimony of the fine Narosky, he's saying he didn't see any type of, physicality per se, other than the pulling out of the car. That's it. That doesn't rise to that level. It doesn't. So what happened here today was an impulse response by my client who, unfortunately, in a desire to defend himself from an individual that is exceptionally inebriated, intoxicated, approaching him with a pocket knife, and everyone carries pocket knives in this particular area, would clearly establish an imminent threat. And with that imminent threat, whether it be murder or assault with intent to do great bodily harm less than murder, he has an absolute right to defend himself, and that's what's happened here. So the charge of first-degree murder cannot be satisfied. Judge, it cannot. The elements haven't been met by the testimony that's presented here. And in light of saying, I'm asking them to score for this.
But I think the issue is whether to bind over on first degree or second degree murder. And the testimony, like for example, the pocket knife. There is absolutely no evidence on this record that the pocket knife was out of his pocket, in his hand, flipped, referred to, known by the defendant, or any of that. So when you look at the evidence that has been established on this record, Mr. Narowski, I believe, testified certainly on a probable cause standard to this being a first-degree murder that he witnessed. And that's the evidence that we have before this court. We heard from the defendant via his 911 call. When Mr. Muhammad is talking about self-defense and he says it's a danger, he did get it right at the end. You have to be in danger of either death or great bodily harm or sexual assault at the time of this happened. There's no weapons that's testified to in the hands of the victim. The victim is 5'8", 171 pounds and inebriated. There's no evidence of any weapon with him whatsoever. There's no evidence of him charging at, running at, punching, laying his hands on, nothing after they're out of the car, nothing, even from the defendant. And so there is not a record of self-defense in the situation. The only question is, did Devin Hackney do something with premeditation or deliberation, or was this a continuous hot blood situation without a chance at a second look, without a chance at a cool down to think about it? And we believe we've established on this record that this 15 to 20 minute period of time had all of that, and that there is probable cause to find over the defendant for first-degree murder.
Thank you. You want another shot at me?
I will.
Go ahead.
Prosecution's done a good job of outlining the specific facts and what may have facilitated. And as it relates to the charging documents as first-degree murder and felony firearm, as it relates to second degree, anything that's not first is second. Certainly, there's nothing on this record in terms of, by the own testimony of Mr. Narowski, that this is purportedly a continuing, happens in a relatively short period of time. There's absolutely nothing about any premeditation or any thought or desire. What you have here at best is some type, and which is one of the elements, and not an impulse, be an impulse, and again, related to the self-defense. That's it.
Thank you both. Well, I'm glad I'm not the trier of fact because there's too many questions that I didn't get any information on. Like the 911 call says he punched me and snatched me up. Mr. Narowski didn't mention any punches. So if there were punches, when did they happen and where did they happen? But you certainly met the probable cause burden to send it downtown for whoever gets the trier of fact job to figure it out. So I'm going to bind over.
In a dramatic courtroom moment, the judge made it clear that decisions must be based on evidence, not assumptions. After hearing hours of testimony and arguments from both sides, the judge acknowledged there were still many unanswered questions,